So without further ado, let us all welcome our first speaker of the day, Mr. Marc Andrew Mitchell Alix, the Senior Anti-Corruption Specialist, live from United States. He will be sharing with us on the US experience in implementing the Foreign Corrupt Practices Act by looking at the case study of managers and companies being charged under the bribery cases. Mr. Marc, please.
Okay, very well. Good morning, everyone. I want to first see you personally and say thank you very much for the opportunity. I think this is a very important topic we're speaking about today. As a career professional traveling around the world in this, I can honestly and sincerely say this is no laughing matter. This is not something that we take lightly anywhere around the world. And although the greed is there, there are always opportunities, but there's never a happy ending to anything that's illegal. And there's always a way to find the criminals, everyone involved, and a way of recovering everything lost. So I wanted to really get that message to you because it's something I deal with on a day-to-day basis. I want to start with my material. Can you see my presentation?
Yes.
Okay, very well. I want to start by first talking about the Foreign Corrupt Practices Act. This is a very important act for us here in the United States because it talks about the reach of the illicit activity and where it's a violation of law. So as recently as in 1977, it was enacted to identify anything unlawful for certain classes of persons and entities. Entities would be anything that's physical, any corporation or anything thereof. And of course, individuals who are, in fact, those who take part or elicit this type of activity. So in brief, I really don't want to get into all the details because I know we all can read. So I'm not going to bore you with that type of information. But I will say that the intention was, in fact, to be more specific to prohibit the willful use of mail or any means of instrumentality of interstate commerce, corruptly in furtherance of any offer, payment, promise to pay, or authorization of the payment of money or anything of value to any person, while knowing that all or a portion of such money or thing of value will be offered, given, or promised directly or indirectly to a foreign official to influence the foreign official in his or her official capacity, induce the foreign official to do or omit to do an act in violation of his or her lawful duty, or to secure any improper advantage in order to assist in obtaining or retaining business for or with or directing business to any person. So essentially, they apply to foreign firms and persons who cause directly or through agents an act in furtherance of such payment to take place within the United States. The global practice is, of course, many acts and many laws within every country for such purpose. So with my examples today, we're going to be talking about actual cases that exist that have passed, where you'll be able to see how actually it's unfolded, how they took place, and the methods that were used in brief. I have my small summaries here, and then I'll be going into showing you the actual cases because I have them also connected. So to begin with the first example, as recently, first let me say that these cases are not once in a blue moon. These are every month, sometimes every week. It could be a very good week of cases, a really bad month of cases. The point is that there's always cases and there are always investigations in the United States or in many of the countries that I work in. So it's not something that happens every once in a while. It's very common. But it's really important to know that we actually do investigate, we monitor, we keep track, and when we're ready, we indict. The SEC in December 16, 2019, the SEC charged a former Goldman Sachs executive with FCPA violations. You might have heard of this case. I don't know, but we'll go over it a little bit. The SEC announced charges against a former Goldman Sachs Group executive, Tim Lessner, for engaging in a corrupt scheme by which he obtained millions of dollars by paying unlawful bribes to various government officials to secure lucrative contracts for his company. He agreed to pay the violation for the violation, and it included him losing his bar. In other words, his legal right to practice law. In other words, he could never practice his profession again in the securities industry. According to the order in 2012, Mr. Leisner, a participating manager for Goldman Sachs, used a third-party intermediary to bribe high-ranking government officials in Malaysia and the Emirates of Abu Dhabi. The order finds that these bribes enabled Goldman Sachs to obtain lucrative business from One Malaysia Development Berhad, a Malaysian government-owned investment fund, including underwriting 6.5 billion in bond offerings. The order further finds that Leisner personally received more than 43 million in illicit payments for his role in facilitating the bribe. These are incredible numbers. $43 million to anyone sounds like the golden parachute for their grandchildren's grandchildren. It is so enticing that almost anyone might consider committing such an act, but there are many that don't, because they know in the end, it'll all be returned, it'll all be found, and it'll cause serious, significant damage, not only to the professional capacity, but to their family as well. To continue, the individual conducted lies at the heart of all bribery schemes. He abused his leadership at Goldman, and by engaging in massive bribery schemes, targeted the highest levels of 2 foreign governments in order to bring the business to the firm and enrich himself. So through the fact that he was finding these deals, he was getting his commissions, he was also getting his salary, but he was also working on getting a little money on the side. Very critical. No one ever gets away with this. All it takes is to find one person who will complain, someone who will notify or call a hotline. We can find it through audits. The chain of command, the chain of transactions is so long, there's always a way of detecting such a transaction. Everything in the end has to be justified through our global banking system, and there's just no way really to get away with much. In his order, he consented that he violated the anti-bribery law. Now, I want to move to the actual indictment. I want you to say this because it's real. Here you have, okay. This is the actual indictment. You see his name, you see the act. These are the violations for the acts, for the laws that occurred. And it talks about who he is. And you'll see here quickly on the second page of this, all these links to all these cases can be found through my material. So you can always find it online. I highlighted certain sections so we can get to it quickly enough because this is a short presentation. And there really isn't that much time for me to even get into how a lot of this was detected, how it was found, but there's enough there so that you could really understand what occurred because it's appalling. Okay, so as you see in section 3 of the summary, it talks about Leisner, Goldman Sachs, the company, a very high level, very distinguished company here in the United States and globally in investment banking. It's probably top 3, easily can be considered number 1 by many. Here it says in item 1 under the summary, the matter relates to a massive corruption scheme perpetrated by Leisner while acting as a senior executive of Goldman Sachs Group. A senior executive of many institutions could be someone as low as a vice president. That could be a senior position in many institutions. In other institutions, a senior position is anything that says senior vice president and above. So it's really not it's not the highest rank, but it can definitely be one of the highest ranks. But in a situation like this one, this is a very well tied in individual to his organization. He was in a position of influence and he was able to negotiate these contracts with simple ease. Leisner, in coordination with other Goldman Sachs senior executives, authorized and paid bribes and kickbacks to government officials in Malaysia and the Emirates of Abu Dhabi in order to secure lucrative business for Goldman Sachs. If we proceed to number 2, it talks about who the Malaysia Development Berhad Company is. It's a state-owned and controlled investment fund created to pursue projects for economic benefit of Malaysia and its people Between 2009 and 2014, 1MDB raised capital to fund its projects in the billions of dollars. Between 2009 and 2014, the diverted funds included a substantial portion of approximately 6.5 billion in capital that was raised between 2012 and 2013 through 3 bond offerings that executed with Goldman Sachs. As part of the scheme, Leisner and other bribed government officials in Malaysia and Abu Dhabi retained lucrative business for Goldman Sachs. They were in fact kickbacks. We signed the deal.
Mark, sorry to
Yes.
interrupt you, but some of the participants have reflected that the screen is still on the Foreign Corrupt Practices Act page. It didn't go to the slide. So maybe you should share the screen for your presentation slide as well.
I'm trying to figure out why it's not working.
I believe you have to click the share screen and choose the specific slide to share. Or else you can stop sharing the current screen and then reshare the screen for the presentation slide.
Is that working?
Yes. Thank you, Mr.
My apologies. My apologies. Well, just to go back a little bit, just so you know where I am, I'm going to reduce. Let's see here. Okay. This is the actual order. This is the actual petition from the court for Mr. Leisner. And I was reading from here, this second page. And you can see here where we talk about the actual money that was taken, the amount, and the parties involved. Number 3, basic. So this indictment, it's very clear and concise. As in any court, you have to explain, you summarize what occurred, what violations occurred, and then you go into what actually occurred. So here in the respondent, it identifies the respondent as a 50-year-old who worked for Goldman since 98 to 2016. So it was not long ago. And I want to remind you, this occurred 2012, 2013, and we're now in 2020. And this case came out in 2019. Okay, so you see there it says December 16, 2019. So it takes time to investigate, but once we identify the parties involved, the lives begin to change because people will actually lose their job. You know, Goldman Sachs will be fined. There's reputational risk because it'll be in the newspaper. You know, all of a sudden your children and your family are involved. So this is a never-ending downfall, and you'll feel the effects of what you've done for a very long time in your life. So as part of the order, you'll see that it talks about all the entities that are related. What we do in investigations often is by tracking the money and tracing the money, we identify who's involved. In other words, it's just not Mr. Leisner. It's him. It's what he did for his company, who in his company knew what he was doing, and then what happened to that money or who received benefit from it, everyone involved in the negotiation. So here you'll see it's Goldman Sachs, okay, major company. There's the LLC of Goldman Sachs, which is probably the one that was working directly with everything that had to do with Malaysia. There's IMDb, talks about the history of IMDb. And then it talks about where some of the funding and the sources were, either who benefited or who provided the funds on behalf of Malaysia. So you see here we have the Middle Eastern Sovereign Wealth Fund. There was an investment fund owned by the government of Abu Dhabi. So here we have 2 governments. Obviously, there are at least 2 people for each of those governments involved with Mr. Leisner. So now we have 3 individuals. And then, of course, Mr. Leisner reported to someone, so we have to see who else is involved. We have the Middle Eastern investment firm, also from Abu Dhabi. You have Joe Low. He is a Malaysian national who advised on the creation of TIA. So he was involved. Although he might not have been the scienter or the person who thought of the scheme, he played an important role and definitely received some kind of kickback. You could also be involved in something like this, never being part of the individuals who make the money or who steal the money, but because of your negligence, your dereliction of duty, your lack of recognizing something wrong, you could still be part of the indictment and you could suffer from something like this. That's why it's always important to be very prudent in your job and in what you do, so that you can avoid or report things like this. That's why in many countries, we have hotlines, we have a reporting structure for fraud. You can always call a government agency and get them involved. Even when you're not sure, there's always some kind of mechanism to find out if something, if your curiosity is in fact correct. So you have institutions like the IAM. There are many worldwide that you could use. So here we have Mr. Robert Ng, who's also a national. He worked at Goldman. He was probably an assistant to Mr. Leisner. And then you have Najib Razak. He was the prime minister in 2009, 2018, and he held a position with the IMDb. So you know there how high this was. I'm certain, given the news structure and the reporting structure there with the media, that many of you have heard of this case. I think from this standpoint, maybe you've never actually seen the docket, the actual indictment as it's unfolded and prepared. So here we have facts. The facts are very important to the case because it talks about the background, who the individuals are and what their role is and how important they were. So you see quickly as we head into facts in the background, it talks about what occurred. The first person that comes up is the intermediary for Malaysia. If you have questions or concerns about this, you can go to Google. You can search this individual by name or by company or the case, and you'll be able to see the pictures. This is nothing very difficult. You put the name in, you go to Google, and then you check images, and you'll get many images of individuals with the very same name. Most likely you'll see a letterhead for a newspaper. Here he talks about his role. Mr. Lowe had advised on the creation of the TIA for the predecessor entity. Although he did not hold a formal title with the company or the government, Lowe worked as a finder and intermediary in relation to the officials and other government officials on multiple financial transactions. Every transaction is a violation of law. So you're not only subject to the act itself, you're also subject to the predicate law or the transactions that occurred for that violation, that illegal act. So you could face 15, 20 counts of bribery or corruption or fraud or embezzlement for one instance. It's really that difficult. So if we continue here, number 16 talks about through his participating managing director, Leisner was retained to provide financial advice to the government of Malaysia with the 2009 federal takeover of TIA, Project Tiara. Notwithstanding Lowe's public denials about any involvement while working on a project, Leisner and other executives at Goldman knew that Lowe worked as a finder and intermediary. This is where Goldman Sachs can no longer say, we didn't know, we didn't see, we have no clue. Willful blindness here does not apply. In other words, Goldman Sachs knew. That makes them subject to civil money penalties because of the fact that this occurred with their company and they were aware of one of these members representing them in some capacity. So now they are subject to criticism. To continue, Leisner and others, including Goldman Sachs Managing Director Robert Ng, at the time knew that Lowe remained close to the officials and the other government officials in Malaysia, including other people, Mr. Najib Razak and from Abu Dhabi. During this time, Lowe also specifically requested that Leisner, Ng, and others conceal his involvement in Goldman Sachs business. He knew something was wrong. He said, well, maybe I'll get something on the side, and that's about it. That's all we have to do. Well, wrong. As soon as they give you your name, you're part of the pie. You are now going to be facing the same charges. So now we continue just to move it along because I have two more cases. I have another one that I really want to show you. And the third is maybe if we need the time. So here's the deal. Part of the process, it talks about what occurred to conduct the activity. As we investigate cases, we start to map out who's involved and which directions the transactions occurred. Comes in this way, goes that way, returns this way, and then it goes down to someone else. We actually create a link analysis diagram with photos of banks, institutions, money remitters, bank accounts, individuals, the mother, the father, the dog. You understand? Everyone. Okay. So it talks about the deals. If we go down to number 21, throughout 2012, 2013, Leisner and other executives of Goldman actively worked to obtain and retain business from 1MDB for the benefit of the company. So now we have Leisner, we have Mr. Eng, we have other senior executives. They were very vague in that because there could have been others involved, but they definitely included 3 plus the intermediary. Promise the payment of kickbacks, bribes and kickbacks to government officials in Malaysia and Abu Dhabi using, in part, misappropriated and embezzled proceeds from the bond deals. During this time, through the course of the scheme, Leisner and others paid millions of dollars in bribes and kickbacks to government officials. In order for this to happen, we go to a meeting, make a phone call, schedule a meeting, sit down in the office, and engage in general conversation. We are not going to decide at this moment who is going to do what. What we are doing, if we are going to engage in such an act, is we try to develop a rapport, a relationship with that individual. We want to see how far the conversation goes on personal matters.
Sorry,
The
Mr.
business aspect, yes.
Sorry to interrupt again. Can you please enlarge the screen sharing? Maybe enlarge the wording because the wording are a little bit small, especially for those who is reading it from the laptop. So
Okay, I'm glad you said that. Let's increase it.
yeah, maybe you can make it
Cool. How about that?
A little bit smaller. Yeah, maybe you need to adjust it from time to time to ensure that everyone can read it. Yeah.
How about that? No, a little more. Okay, hold on.
Right,
Right
good.
now, let's
That's
leave
good.
it there.
Thank you.
Okay,
Sorry for the interrupt.
not a problem. So I wanted to talk to you a little bit about what happens. You know, sometimes we go into a meeting, and whether you know it or not, there's a camera there. There's a voice recorder under the desk. There's a voice recorder next to the lamp. There's a voice recorder. Sometimes you see they have these conference phones, these big phones. They look like stars. They look like starfish. Sometimes those phones are on. Somebody's listening in another room and it's being recorded. Even though today's practice in most institutions is to turn your cell phone off and put it in a bucket or a cabinet outside the meeting place, very standard these days. You don't know what's happening in it. So the people who are going to engage in this kind of thing are not going to speak freely, but they're looking for the relationship. They're looking to see, can we go to lunch? Where are we going to have lunch? Are we going to have lunch the next day? Would you like to have dinner? Where would you like to have dinner? Would you like to meet my family? They're looking to build more than necessary a relationship that really has nothing to do with the actual contract with the deals. This happens before anything is signed. Sometimes somebody from one group sends a messenger to another group. Sometimes they say what we call a kite, a message. Are you interested in such a deal? It's possible that maybe this situation could arise. In other words, they'll throw some low-hanging fruit to see if someone says, yeah, I'd be interested in that. We can talk. And then they set up a meeting place. Where? The golf course, the local gym, a bar with a lot of noise. So it happens. These things don't happen in the office to begin with, because in the securities industry, I was a director for TD Securities for the North American region. I was about 32 years old. I was responsible for, 600 people. But every phone call in a securities bank, an investment company, is recorded. So we know the most you could do is talk to your kids and everyone else, but you really should keep your conversation to your business. No one is going to really offer anyone anything illegal in an investment bank, because there's a separate team that monitors all the calls, especially for those of traders and the investment bankers. Happens every single day. And those phone calls, those recorders are never turned off. And those recordings are retained on a hard disk, sometimes for as long as 10 years with some countries. So it doesn't go away. In other words, it'll always be there so we can trace back to maybe the first point of contact by phone. So what I'm saying to all of you here is these things don't happen by mistake. They're intentional. There's a method to actually getting someone to play a role in something like this. And it can happen very easily because money is very enticing. Okay, so I hope you can all see it now. So what happens? Step 24, it starts to talk about the process. I'm still talking about the process, and I want you to realize something. This is the actual indictment. This is what the court sees. This is what the jury sees. This is where all the evidence ties to. So these comments tie to some real evidence. Goldman obtains Project Magnolia from the Malaysian Sovereign Wealth Fund. Okay, happened in or around early 2012. Leisner and other executives of Goldman met in Malaysia, including Lowe and with other 1MDB officials. The purpose of the meeting was to discuss the proposed purchase of the company and Goldman's preparedness to help obtain financing for the purchase. What do you have? What do I have? We're matching pieces now. Do you have your end of the deal? Do you have your end of the deal? Where do we meet? Where are the gaps? Do you have a Marc Andrew Alix working in your office? Is he going to be in the office that day? Because you know if he's there, there's no way this is going to happen. These things happen. Okay. If we go to 26, you'll see in late February 2012, Leisner and other executives of Goldman Sachs met with Lowe and the officials in London to discuss the proposed financing. During this meeting, Lowe explained that in order to secure the guarantee from Middle Eastern sovereign, they would have to pay bribes and kickbacks. Like I said, it's not going to happen in the office. Never is. It's going to happen on an airplane in an airport at a separate location because maybe they had to go to London to speak with other representatives or the other part, the third part, which is from Abu Dhabi. So they went to a neutral ground where they know that they could sit in a pub or somewhere else and speak freely because no one's going to go to the other person's hotel room or conference room in a hotel because they really don't know how that room has been set up. So this is going to have to be, this happens in a place where no one really has a time to repair, to sort of betray the other. This has to do all with trust and lack of trust. So if you look at 26 and 27, it still talks about all that and everything that occurred, and you can see it's a sequence of events. And during this process, of course, Mr. Leisner, he had to go back to his management and say, look, this is where we are. What's it going to take to get the deal? If we don't get a deal, we're going to lose our job here. Let's get this deal. We're going to look good. We're going to make our commission and we're going to get a kickback. In investment banking, investment bankers always worry about, there are sort of goals that have to be met. You have to bring in a certain amount of business sometimes. $1 million a year, 2 million, 5 million, 10 million, depending on your sector, your level of expertise, and who is in your portfolio. Who do you bring with you to Goldman that you can rely on for investments? Investment bankers move from company to company to company with, to picture it some way, a Rolodex box. And in that Rolodex box are all the contacts, and these people have money to invest. So this is the kind of pressure they live under, and this is the kind of thing that can happen. So you see in item number 32, Goldman transferred the proceeds of the Magnolia bond offering via wire to 1MDB. The fact that they transferred it by wire is another violation of law in the United States. And we talked about that at the when we talked about the definition of the Foreign Corrupt Practices Act. It's a violation of that law, but it's also a violation of wire transfer rules. We have so many laws in this country that many countries copy and use as their own, that the amount of violations will stack up. You could end up serving for life in prison, and many have served more than 25, 35 years. So they transferred the money, and they knew that a large portion of the proceeds of the bonds would be diverted to themselves and others, including government officials, through shell companies beneficially owned and controlled by Lowe. What's a shell company? Shell company is an institution created with no physical presence. What does that mean? That means might be a state or two in the United States, or there might be a province somewhere in some country, or there might be an island. In the world, we have places where you can open up a company with no real physical presence. Aruba, the Bahamas, Canary Islands. There are places where you literally fill out a form online, you submit your payment, and your company now is in Malaysia, in Aruba or the Bahamas. I had a time where I was working for someone and we were investigating certain shell companies. So I had a very large portfolio, and I went to Aruba in the Bahamas, and I would go to these places where they were just basically, it was a building, a very nice looking building, with all the tinted windows because it's a hot climate, and you go in, and inside the lobby, from the lowest tile on the floor, up the wall to the ceiling, maybe 4 stories up, there would be nameplates about this wide. Let's say they were 4 by 8, 4 by 10. And each of those plates had a business on it. This is the recognition of your business at that location in that country. Not every business had a plaque, but the entire entrance of the lobby was covered in gold plaques. That was it. There's no office, there's no representative, there's no one. There's that address, and that's there. And of course, there's a directory in the lobby where you could look up all the companies and see who's actually domiciled there. Shell companies for money laundering purposes are prohibited. You cannot open a bank account for a shell company. It is very difficult. However, in some of these countries, you can. So in money laundering, as a money laundering expert, we track not only transactions for individuals, but also if anything passes to or from an offshore haven for shell companies, we know that there must be a reason for having that offshore account. Why? They have these accounts first to hide money, two, to avoid paying taxes. So, like I said, the violations of law continue to stack up. You must pay your taxes, right? Every country is the very same way. So that's what a shell company is, for those of you that might not have known that. So in most cases, if you don't have a physical address where you could show on your driver's license and a real physical utility bill, you're not going to be able to open a bank account and engage in transactions. But not only do we monitor the accounts of individuals and where they're domiciled, if in fact it's a physical presence, we also monitor the transactions. What does that mean? That means that if you send a wire and the wire says you live here and that person lives there and they're receiving money from you, we are tracing, we are verifying your address, but we're also verifying their address. So if that comes up as a shell address, a shell company address, you are now part of a possible investigation because this information gets reported to a financial intelligence unit within that country. So maybe from a simple transaction of $1,000, they find that the beneficiary or the sender has sent many more to your country or from that country, but could be part of a bigger sphere of influence for a particular set or grouping of transactions. These can end up being as big as something like this. I can tell you that because it's what I do for a living. Okay.
Mr. Mark,
Yes.
we are moving into the Q&A session soon. The Q&A session will start at 10:45. So maybe you can summarize up for this case.
Yes.
Thank you.
Okay. First, let me say that I'm very happy that we discussed one case instead of 3, and I had to rush it. I always find that there are many things and different components that I can address. So for me, it's about making sure I give you as much information that you can read and take home because we can all read. And that's really what I aim for. So within my presentation, you have 3 cases and 3 dockets of actual case files. I have highlighted the key comments and things you should be aware of. You'll see that as I'm closing up, we're basically talking about how it all ends. So they obtain the project, it indicates who they are, and then as you can see, it continues to map what actually occurred. If you wanted to take the time to actually go through this actual case, all you have to do is sit down and map out a box for every step and just draw the lines, and you'll be able to see exactly what occurred within this set of transactions. And with that, I also want to mention one other thing. In my presentation material, for today, there's a list at the end of the, I believe it's page number 6 or 7. There's a list of cases. They are all linkable on the internet. There are many more cases that I selected from 2019 that you can look at. And if you went into the SEC's webpage today, you could probably find at least another 10 months worth of cases for this year, 2020. It never ends because people are always fall prey and subject to greed. And it's a sad thing. Now, with that, I close. I hope that many of you might have questions for me. And if you don't, that is fine. I've given you a lot of material to read from. But if not, you can send any questions to the group here managing the conference, and they'll get them back to me, and I'll respond without any difficulty. Thank you so much.
Thank you, Mr. Mark. Actually, there are some questions from the participants. So to ladies and gentlemen, Mr. Mark will now answer some questions that were sent during his presentation. So
Go back to page 1.
hello. Hi, Mr. Mark.
I'm
Can
here.
you stop
Yeah.
share the screen first?
I'm looking for the way out of here.
And to the participant, we saw that some of you have commented that you would like to get the materials from the speakers. Regarding this, we will talk to the speakers later on. And if all the speakers agree to share their material, we will email to you later on. And the first question, how success is FCPA in US and what type of practices can we adapt in Malaysia?
Oh, very good question.
Yeah.
It's extremely practical. Oftentimes, a lot of these cases come about because of there are many audits that occur. Institutions are audited internally by their internal department, internal audit group. They're also audited externally from their regulator. In most countries, you have your auditors, you have your regulators. Those findings are often part of the initial starting point for something like such a case to occur. So it's extremely practical. It happens a lot. It is very common. In Malaysia, I think you are in the process of developing similar laws. And what you're going to see is that over time, as the experts and the analysts become more qualified or more comfortable with what they find, they will start to produce actual cases that can be investigated. And then once this starts to really get into the mainstream media, those who might be thinking of something might decide not to engage in such a transaction.
All right, thank you. The next question is, since 17A of MACC Act 2009 has just been enforced this June 2020 in the midst of COVID-19 pandemic, from the US experience, what can be done or improved to make sure that this act can be implemented in a way to meet its objective?
Training. A lot of training and understanding. I have been doing this for a very long time. I work with general prosecutors, I work with the intelligence agencies, I work with the regulatory agencies, I work with the actual ethics commissions and secretariats of presidents. And they always say, I know the law, but tell me what it really means. So we'll go over their law, and then I tell them under practical terms what it really means, what it looks like on paper. So I show them things like cases where they could say, look, this is a type of scenario we're looking at. And look, it happened here in country X. And then when they can start to look at the same type of flow, then they start to understand that it's really not normal for any country to fall to something like this. In other words, it shouldn't be because a certain individual was in a position of influence and they took advantage of the country and now they're no longer in that position. No, you want that money back. And when you identify that you want that money back because it belongs to the citizens of the country, then you realize that laws have been violated. So I think in the process, the COVID-19 is probably causing some delay in a lot of countries because many courts are closed. Some people are not working as efficiently as possible. But it doesn't mean that justice has gotten away. I myself have to be somewhere in another country and I can't go to work right now to one of my locations because of COVID, but the work is still there. I said, do you want me to go there? No, we're waiting for you to come, but we need to make sure that we're all healthy for you to come and do your job. So it never stops. It may be postponed for a little bit, but it's always there.
Okay, thank you. Let's move to the third question. So can you compare the Malaysia's Section 17A and the US FCPA and the UK Bribery Act and compare how the different environment affect the outcome of implementing this law?
Whoa, I'm going to have to get back to you on this one because you're asking me for a comparison. If I speak just off the top of my head, I'm going to forget something. I might say too much. I'd rather protect myself and show you a diagram with the 3 columns. I have to err on the side of caution. Although I can explain it briefly, it really wouldn't do you justice for me just to talk about, this kind of comparison. But there are some differences. But the gist, the substance, the purpose, the reality of what the laws are, it's there. It's just there are certain nuances. Sometimes it could be as small as how far back you can actually investigate and indict for a crime. In some countries, it's without restriction. In some countries, it's 15 years. In some countries, it's 25 years. Some countries say, 4 years. Others say 10 years. So I have to get back to you on that. If you really want that, I can produce that that comparison. Actually, I think I have it. I just don't have it here at the moment.
Hi, Hi, Mr. Mark. So there is one question from the participant. Beside the Goldman Sachs case, which is linked to 1MDB, perhaps you can share with us another one case study purely took place in US, but because of the time, we have another, say, 5 to 6 minutes. Do you mind sharing with us another cases?
Yeah, I could show you.
Yeah.
1 second.
Okay. So we will pass the floor back to Mr. Mark.
Let me pull out another one here. I'm trying to think of best way to address 5 minutes for you. Okay, so we go to this presentation. Let me see if I can share my screen. We'll get this right. Okay, can you see that? Yes? I didn't hear anything. Okay, this is the presentation that you'll be receiving today. You're also going to be getting the exhibits, okay, the court cases. So what I've done for you here, because I really like to be as comprehensive as possible, we talked about this section. This is what I started with. It's always good to start with the law. You'll see there are 3 summaries here, but in the back, I have this. This is a list of the United States Foreign Corrupt Practices Act, the Foreign Practices Act enforcement actions for 2019. There are 3 missing. Those 3 are the 3 that I listed above. You could see here, it's quite extensive. And from the bottom, towards the end, February and April and January, there were another 3, which I took off because that's also in the submission item that I gave to the IAM. So basically what you have here, take a look at all these cases. Folks, this is a lot of work. One case could take a year, 18 months to develop, to finding the contacts, the interviews, the confessions, tracing the money, traveling or getting other countries to cooperate with you. Sometimes a phone call is not enough. Sometimes you have to actually pull out something that the 2 presidents signed 40 years ago that says you share information for investigative purposes. A lot of this is not easy. But again, the importance is foreign individual, US company. So for Malaysia, it would be foreign individual, Malaysian individual. So here you could see something as simple as Barclays. The UK-based bank agreed to pay 6.3 million to settle violations of internal accounting controls and record-keeping provisions in connection with its hiring practices in Asia, because they might have violated some bribery laws and they couldn't really pin down who, if the person was told to do this as a matter of practice, like it's their job, do it. You don't know what you're doing, but do it. So they penalize the bank. They find these agreements. A lot of them are big, a lot of them are small. Here, Technip FMC PLC, the global oil and gas services company, agreed to pay more than 5 million to solve violations of the FCPA for internal accounting controls and record keeping provisions for the company. you will always see accounting and operations and record keeping controls mentioned in a lot of these indictments. Why? Because you have to hide it. We know that it's a $6.5 million contract, but at some point they stole 2 million. But how do you hide the fact that you've taken 2 million when the contract says 6.5 million? So you have to, in effect, falsify documentation within the organization to make sure that in some organized chaotic order, the 2 million that was stolen aren't accounted for during the audit process or at the year-end closeout. Most financial institutions have a year-end closeout. It'll occur end of October or end of December. Some do it quarterly. What is that? This is a point where a foreign institution in a foreign land must account for every cent paid or received for that year as it is brought into the institution and taken out. In other words, when you have a foreign institution in a foreign country, that foreign institution is representing a company in another country. That means that there's always an upstream of money. They send money to invest, but when you make your earnings, you must pay back whoever made the investment. So there's an inflow and an outflow of money. So oftentimes during these audits, there are differences. I was an executive at a very young age. At the age of 25, I was the vice president for one of the largest banks in the world, a foreign bank. Every year we had end of year closeout. It was October. All executives would stay in the bank and the institution till about 5 o'clock in the morning to make sure that the books matched, especially in cases where there's one accounting standard that had to match another accounting standard. And this is where the accountants play their role in explaining how they account for payments and transactions within the US and their company, and then how it maps through general ledger, through a chart of accounts, to the accounting requirements of the home bank in the home country. There's a difference. You don't want that difference to be $1 million. You want that difference to be 10,000, 5,000, because it's easy to find. If you see that that amount is off $1 million, 2 million, something happened. What happens is most of these guys want to go home. As a compliance officer, I'm the guy who says, nobody leaves here until you tell me where every penny comes from, and I want to see it. So we would literally stay there till 5, 6 o'clock in the morning, find the transactions and make sure before I signed it, because when I sign it, then the general manager of the institution would accept it. But I would never accept nothing for over $1 million, because effectively that means that in translating the transactions, somebody switched some numbers. And that's a good way to steal the foreign institutions in foreign countries, from foreign countries to foreign countries, from one country to a foreign country. Yes, are you ready?
Okay. Thank you, Mr. Mark. Thank you once again for answering those questions and also for your very interesting presentation today. Thank you for staying up late. We know that it is almost 11 p.m. in Florida. Thank you. And I hope everyone else really benefit from Mr. Mark's session. Once again, thank you.
Thank you. Bye-bye.
Bye.